have somebody actually force the time on me, please.
Oh, yeah.
I want to begin by taking issue with the notion that Section 230 represents internet exceptionalism. It is certainly true that if a defamatory or otherwise illegal statement is printed in a newspaper or a book, the author is liable. A bookseller or a news vendor can be held liable if it has notice of the defamatory content and still sells it. But nobody would say that the printing company is liable. Nobody would say that the news girl is liable, or the post office, or the delivery service. Nobody would say that the newspaper that carries ads for the book, or the credit card company that accepts payment, although maybe there's some movement in Congress on that with respect to copyright violations. Nobody would say you can sue the library for continuing to stock a book and lend it out even though one sentence in the book has been declared unlawful. Wouldn't occur to anybody to sue those people. Section 230 ensures that similar rules apply to suits against online intermediaries. Now, in my practice, I represent message board hosts, hosts of consumer websites like the one you see in front of you, defending Section 230 immunity, and of course you have to represent the host in order to have standing to assert the Section 230 issue. But the reason we're in this issue at Public Citizen is protecting the public's right to use the internet for purposes of communication. So I want to begin by taking a few minutes to explain why I see Section 230 as the linchpin of online free speech in this country, and then respond to some of the suggestions for reform. So take a look at this website. You can see at the bottom a negative review from a consumer who says, I paid for a service from this editing company and they didn't do what they said they would do. And then you see above it a second review which says, in effect, my first review elicited an appropriate response. They paid me back. They refunded my money. So Lombardino, the person who's criticized here, contacts the message board host and insists that the review be taken down. Now, I think we ought to ask, is this good public policy? Isn't it better for the consuming public to know, first of all, that maybe you can't trust this guy, and second of all, that if you complain publicly, you might get some results? Without Section 230, Lombardino could contact the site operator, a company named sucks.com, and threaten a defamation suit. Say, what she said about me is false. And the operator then has to decide, could Lombardino succeed in such a suit? And the operator has to then assess the truth of the accusation. Now, how does the operator do that? Does it take statements from both? Do they have to be statements under oath? Do you cross-examine the two individuals? And how much does it cost to evaluate the truth or falsity of these statements? And certainly the cost of defense are greater than any benefit you can possibly get from the page, even if there were ads or another revenue basis for the site. And if you look at the website in full, my screen is too small for this, you'll notice there aren't any. This is a purely eleemosynary site by somebody who got ripped off on some occasion decided to set up a site for other people to communicate. I don't think he ever has plans to monetize this the way other people have done on various sites. So if the site operator refuses to take it down, and my client did, Lombardino then escalates and goes to the site operator's hosting service. And if the hosting service doesn't back down, then he goes to the hosting service data center. And this isn't a joke. This is what actually we see happening in our practice. And it happened in this case, as I'll explain. And the danger of a notice and takedown regime is that the notice becomes a heckler's veto. 1 weak link is enough to take down this content. Now, this isn't actually the issue that Lombardino escalated, because Section 230 protects against defamation claims. Instead, I'm going to scroll over here. What he did, there we go. He escalated over this. The site operator posted his email exchange with Lombardino. And Lombardino demanded that this exchange be taken down because he said his emails were confidential and proprietary. And when the site operator told Lombardino to go jump in the lake, Lombardino went to the hosting service and served a DMCA takedown notice. And to make sure, he also sent the DMCA takedown notice to the hosting service's data center. Now, some people in this room are aware that I have a history on these claims, that cease and desist letters are copyrighted and that posting them are actionable. It's a stupid claim. And our client actually announces on his website that if you send me an email complaint, I might put it up on my website, so you could say, if you believe in click-wrap licenses, that he's got a click-wrap license. But unlike the Section 230, the DMCA allows liability on a notice basis. And in our experience, site hosts cave immediately when they get even the dumbest takedown notice. I have relationships with some good site hosts, but they will stand up against these defamation claims, even the libel tourism type defamation claims before the Speech Act was enacted, but they just cave immediately. The first time I used this example in a talk, I couldn't have shown you the exchange because the hosting service told my client he had to remove the email exchange or his whole site would be shuttered. So this difference in treatment speaks volumes to the vital importance of Section 230 to protect critical speech, the ability to put it online where the relevant public can see it, and the ability to keep it online once it's been challenged. ISPs do generally refuse to remove criticisms based solely on complaints about falsity, not always, but when the complaint is based on falsity and harmfulness comes in with an IP label, our experience is that ISPs respond like Pavlov's dogs, they take it down. And so the danger of any change in Section 230, even for some small segment or some of claims, some kind of causes of action, is that it may lead to a vast increase in the effectiveness of the headless veto. I worry especially about the copyright angle because those who want to suppress speech are increasingly turning to IP theories. You use my name to say what your web page is about. You put my name in the meta tags or the title tags, or you put my logo up to illustrate what you're talking about, and the ISPs will cave into those claims. Then there's a medical justice group that Eric Goldman has done so much to combat, encouraging doctors to get their patients to sign agreements, turning over the copyright in anything they may eventually write about the doctor, so that the doctor can then serve a DMCA claim. We're also seeing threats to sue site hosts for their refusal to identify anonymous critics. Due to the work that we've done over the last 10 years, most state and federal courts have adopted a reasonable system for targets of criticism to seek relief against anonymous critics. The dendrite standard, you provide notice, you make a factual and legal showing of wrongdoing, and most courts, when we approach them with a reasoned argument about this system, buy into the approach. And it's an easy enough standard to meet for the critics, for the people who have been criticized, but plaintiffs don't like having to meet the standard. So we often see threats to the host. They will be sued if they don't reveal the identity of the anonymous critic, and Section 230 provides key protection here. Now the challenge, one of the important challenges to Section 230 these days, it comes from a book called The Offensive Internet, published earlier this year from a group of scholars, either currently or by historical association, associated with my own alma mater, the University of Chicago Law School. They ascribe much of what is harmful online to the ease with which speakers can put their stuff online without attribution. Several authors suggest a trade. ISPs should be able to keep their immunity, but only if they give up the identity of their users, either by not allowing pseudonyms at all, or giving up the identity of their users on demand, or supplying the identities in response to subpoenas, no questions asked. But what these authors never explain, and I've tried to ask them, is why the dendrite system of giving notice and making a showing isn't a sufficient protection for those claiming harm. An additional problem is that these authors undervalue anonymity. Criticized parties sometimes seek to identify their critics not because they have a genuine case that they might have a chance of winning in litigation, but for purposes of intimidation or retaliation. And there is sometimes a very good reason for anonymity. The First Amendment, of course, protects the right to speak anonymously. And unless there's a judicial check testing the validity of the claim, There's no reason not to seek to identify critics. For the same reason, there's no reason not to claim falsity if you know the heckler's veto is going to lead to the information being taken down. There's no reason if the website operators know that as a practical matter they're going to have to give up their immunity unless they disclose the identity. As a practical matter, why not make the demand and get the identity? As a practical matter, the right of anonymous speech will be lost. Now, I asked several authors from the Offensive Internet book to appear on this panel and have a debate about the subject, including one author who was on the last panel, but all of them had better things to do. Then we have Gavin's point, and I'm very grateful for Gavin coming, which I understand to be to try to adjust the immunity in part depending on the type of harm being claimed or maybe the cause of action that's being alleged. Or other things that might reduce the cost of some claims, but not eliminate the cost, I might add. Two things worry me about his proposals, and they both pertain to boundaries. We can all agree that certain kinds of harms are very real harms, and that if we have a violation of certain rights, that repetition should be eliminated. But the problem is not just the valid cases, but the claimed cases. We have to recognize the heckler's veto problem. If website operators and those up the line recognize that they can be held liable if they guess wrong, even if they reasonably guess wrong, but they might be held to later have unreasonably guessed wrong, they will just knee-jerk take down, even if the claim is a stupid one, so why take the chance? Second, how do we limit the scope of the exception? Why not bullying? Everybody's against that. Why not stalking? Why not employment discrimination, discriminatory advertising? And what about the protection of reputation? We have a cause of action for defamation here in the United States because our society places great value on the protection of reputation. So why should defamation claims be excluded from the DMCA exception? Now, here in the U.S., thanks to a rare political moment when politicians on opposite sides of the aisle got together to propose the DMCA, we have excellent protection. We have two exceptions, the IP exception and the federal criminal law exception. We can argue about whether these are good exceptions or whether they're overbroad in some respects, but I'm not in favor of reopening the question of exceptions because I'm not sanguine about containing the broadened list to only those places where we might all agree that there's real harm. Now, in opposing reform of Section 230's exceptions, I don't deny that some people can be truly harmed by online speech. My concern is rather with the consequences of the opposite rule. But in saying that, I do think there is some danger of overstating the extent of harm suffered when unlawful speech is left online. First of all, many hosts do respond to real problems by taking material down, even if all do not. And hosts are susceptible to political and public pressure when they don't take down. Craigslist stopped carrying sex ads when the press got really bad. In Barnes v. Yahoo, a case where we were involved on the question of whether you can raise the defense in response in a motion to dismiss, Yahoo in that case responded to a threatened hearing in the Oregon legislature by promising to remove insulting material, and this really happens. So there are counter pressures. Are there rogue websites that flaunt their nasty material? Yes. But let's not ignore the cost that those sites pay. They likely lose audiences that they might care about. And you know, when somebody sees graffiti on the bathroom wall saying that you could call Paul Levy's telephone number to get sex acts of a certain variety, I expect most readers will understand that it isn't true. And that the real meaning is that there is either somebody who hates me or somebody who's jealous of my prowess, or both.